This is another iRaw podcast. We podcast to make the world a better place for animals.
Dr. Siobhan O'Sullivan does like knowing animals. Dr. Siobhan O'Sullivan does like knowing animals.
Hello everyone, and welcome to Knowing Animals. Knowing Animals is a podcast in which we speak to animal studies scholars about a piece of their work. I'm Josh Milburn, and I do like knowing animals. This episode of Knowing Animals is brought to you by AASA, the Australasian Animal Studies Association. This year, their annual conference, with the theme of Flourishing Animals, will be held online. By the time this episode has been released, the call for papers will have closed. However, you may still be able to register. Registration is free for AASA members. The episode is also brought to you by the Animal Publics book series from Sydney University Press. The series is currently accepting proposals, so if you're working on a book on animal studies, from any disciplinary perspective, you should consider getting in touch with the editors. The editorial board is made up of people from all kinds of disciplinary backgrounds, well representing the diversity of animal studies scholarship. Today, I am very pleased to introduce you to Dr. John Adenitire. John is a strategic lecturer in the School of Law at Queen Mary University of London. Much of his research has focused on legal rights of exemption and anti-discrimination law, and he is the author of the 2020 book A General Right to Conscientious Exemption, published by Cambridge University Press. He also works on animals in constitutional law and in legal theory. Today, we're going to talk about his paper, The Rule of Law for All Sentient Animals, which is, at the time of recording, forthcoming in the Canadian Journal of Law and Jurisprudence. Welcome to the podcast, John.
Thank you so much, Josh, for having me.
So can you start by telling us what inspired you to work on this topic?
Yeah, of course. So I do a lot of work with Dr. Rafael Fazel. We completed the PhD together at Cambridge, and it got me interested in thinking more about the role that the law can have in furthering the rights of animals. And in particular, given my specialism is in public law and constitutional law, the role in which constitutional law can further the rights of animals. And so we started exploring this idea that it seems that the constitutional law and theory scholarship, there's very little, if almost anything, on animal rights and animal law in general. So because various disciplines in law and politics and philosophy have gone through what some people call the animal turn, we thought that it was the turn of constitutional law to go through that animal turn too. So we have been working for a year or so, maybe more, on a book which we have submitted a proposal for on animals in constitutional law and theory. So this paper is a part of that larger book project. Yes. But I published this independently because I thought it could stand as a standalone paper. Yeah, the book project involves considering how constitutionalism and the principle of constitutionalism should be retaught to incorporate the well-being and the rights of sentient animals. Right. So one of the principles of constitutionalism is the rule of law, and so this paper is a way to rethink theories of the rule of law to incorporate non-human animals.
Now, I feel like we need to get up to speed on some legal theory to really understand and appreciate the significance and contribution of this particular paper. So let's start with that idea of the rule of law.
Mm-hmm.
What exactly is the rule of law? And what's the difference between formal, procedural, and substantive understandings of the rule of law?
Yeah, so the question what the rule of law is a big question in legal theory and in constitutional theory. And I do not take a strong stance on defining what the rule of law, but I do take a stronger stance in defining what the rule of law is for and who it is for. So there are two operating theories in the paper on this question. The first says that the rule of law is for those subjects that I call active subjects that can engage with legal norms, right? So the rule of law is for rational agents, and the rule of law helps them plan their lives, right? They can engage with norms, they can engage with legal rules, and so the law and the role of a legal system is to enable them to plan their lives. Of course, this means that non-rational agents or non-rational subjects like very, very young children, severely disabled, cognitively disabled humans, but most importantly for the purposes of the paper, non-human animals are excluded from the scope of the rule of law. So the rule of law is not for them because we assume they cannot plan according to legal norms. They cannot engage, obey, disobey legal norms because they don't have those intellectual capacities. And so if we assume that the rule of law is just enable people to plan their lives, to guide their conduct, then we exclude non-human animals and the other passive subjects, as I've called them, from the scope of the rule of law. So I propose a second way to think about who the rule of law is for and what it is for. And I propose that the basic idea of the rule of law is to constrain arbitrary power. So anyone that can be victim of arbitrary power, which I shall explain in a second what it is, falls within the scope of the rule of law. The rule of law is for them. A legal system is for them as well. So by arbitrary power, I just mean power that is unconstrained and that is unaccountable. So there are many ways in which our current legal system treats animals in arbitrary way. For example, fish, marine animals, are not subject to any welfare legislation. They can be killed, trapped, however maliciously or however beneficially the person treating the animals want. Yes, we can catch fish with no legal consequence, almost, at least in terms of welfare laws. So this way of acting arbitrarily, I say, on this second conception of the rule of law, violates the rule of law. So there is also, you asked me about these different conceptions of the rule of law: formal, substantive, and formal, procedural, and substantive. Now these are all variations on this that depend on the basic ideas that we have of the rule of law. If we focus on this first conception, the one that says that the rule of law is to enable conduct, to guide conduct, then the formal account focuses on those properties of the law which enable people to understand the law. So the law has to be clear, has to be known, public, has to be general. All of these formal attributes of a legal system that enable people to actually know what the law is, relatively. Of course, people may need lawyers to interpret the law. You may need a judicial system. But in general, these are the formal accounts that make a legal system function and make it functioning so that it can guide conduct. So a procedural account is a bit more demanding than a formal account. It also requires that the law be interpreted and be applied by independent and fair courts. So the procedural account focuses on legal procedures and fair procedures. So it requires judicial independence, system of representation, good standing in courts, and all the things that we think are associated with a just and fair legal system. Yes, just in a very thin sense, in the sense of well-functioning legal system. And this, from this account of the law of the rule of law that guides conduct, it only means, well, once we know the rules will be applied by independent and fair courts. That's all it means. Yes. And then we have substantive accounts of the rule of law, which are what I can call moralistic accounts. They demand that the law itself be responsive to the requirements of justice, the requirements of morality. Usually that means that legal systems have to recognize fundamental rights of some sort. So in the case of humans, it will be human rights, constitutional rights, such as free speech, free association, and the likes. Again, if we go back to this conception of the rule of law, which is all about guiding conduct, then the fundamental rights that will be picked out most chiefly by these conceptions are those fundamental rights that enable people to have a conception of the good life, right, and to associate with others and to plan their lives. So, we have all sorts of freedom of speech, freedom of thought, freedom of association. Again, these rights are so important for people that can think, that are rational agents. Okay, so these are the three sub theories of the rule of law, right? But these very much focus on this first idea that I've talked about, which is about enable people to guide their conduct, to plan their lives. In the paper, I suggest that we need to move away from this guidance of conduct to prevention of arbitrary power. And so I set forth three theories of the rule of law, tracking this formal, procedural, and substantive account, which focus more on this prevention of arbitrary power, and I explicitly include non-human animals. So tracking the formal account on my non-arbitrariness account, non-human animals could not be killed arbitrarily or harmed arbitrarily anymore. They could still be killed and they could still be harmed, but under this theory, which is not very demanding, the law would need to regulate. The example I give is we have all of this legislation, animal welfare legislation, which does not apply to marine animals, fish. So under my formal account, this would be a violation of the rule of law. Yes, we would need the law to regulate this, the power that humans exercise against fish. So the law needs to apply in this scenario. A procedural account is slightly more demanding on my account, and it would require not only that the law applies to let's say marine animals, but that animals are regarded as part of the legal community. Yes, so that they are able to enforce the rights that the law confers on them, however small, however few rights, or however not strong rights there are, right? And this is a problem that animal advocates are facing at the moment, because standing is a big issue, right? Standing is just this legal concept, which means that you can go to court and enforce your legal rights. Animals at the moment do not have standing. So even if animals are protected by welfare laws, sometimes it is very hard for animal advocates to enforce these welfare laws, because animals do not have standing in their own right. So my procedural account, practically speaking, boils down to this idea that animals should be able to enforce in court the rights that they have, right? And then on my substantive account, I argue that the law should recognize constitutional rights or fundamental rights for animals. I do not specify a list of constitutional rights, but the right to life, the right to physical and mental integrity, the right to freedom would be some of the rights that non-human animals would have. And so this would mean that the law could no longer treat animals wickedly, right? It would have to treat animals in accordance to their moral entitlement as a sentient being.
Yes, I see. So, what you're essentially doing in this article is you are rejecting three leading theories and then proposing three more animal inclusive theories in their place.
Absolutely, yes.
Which is quite an achievement for a single article.
Yes, I think I packed a lot of things in this paper, but it's just very clear to me that our legal theory needs to be redone afresh, because it seems to me that once we accept the premise, which many people do, right, that animals count morally in some sense. Yes, they don't need to count as much as humans, but as long as we recognize that animals count a bit, morally speaking, then having legal theories that exclude them a priori, yes, does not make sense. So it's actually very easy, once we put our mind to it, to start rethinking many of our legal principles to incorporate the status of animals. right? And what I do is I don't even argue that we should adopt a substantive account of the rule of law, right? One that takes us right to the animal rights movement, right? But I talk about this formal, the procedural accounts, which are less demanding, morally speaking. So the legal scholars, even those that do not embrace animal rights, are even more likely to embrace this animal rights turn or this animal turn, even without embracing animal rights.
Now, part of what you're saying is that if we accept the kind of moral intuition that animals matter,
Mm-hmm.
then that leads us to a different kind of legal theory.
Mm-hmm.
But there is at least, well, there's another element to the argument that you offer against these accounts that exclude animals. And that's the fact that animals do, as it happens, have rights in existing legal structures. Now, this is a claim that might strike some people as quite surprising. I know I sometimes say things like, of course, though animals have rights, they're not recognised in any existing state. But you want to challenge that. You do think that animals in most jurisdictions, or at least in many jurisdictions, do have legal rights.
Yes, so we should be careful about what we mean by legal rights. So if by legal rights we mean something similar to fundamental rights or human rights or basic rights, then I think that your intuition is correct that most animals do not at the moment have those strong rights. But if by legal rights we just mean rights conferred by the law, even though they are not very strong, then yes, of course, animals in many jurisdictions have these thin rights. And they have them through what we regard as animal protection laws. We call them animal welfare laws, anti cruelty laws, animal welfare laws, right? Which protect the interests, usually in not suffering unnecessarily, of animals, right? And even in cruel industries, animal husbandry industries, these laws, at least on paper, they apply. Yes, of course, I'm talking on paper rather than in reality in this sense. But still, and the reason why these laws exist is because legal jurisdictions explicitly or implicitly recognize that animals are sentient beings. Right. So in EU law and shortly in UK law, with the sentience bill, animals are explicitly recognized as sentient beings. What I take sentience to mean is that an animal has a subjective experience of reality. Yes. So things they can experience good and bad things that are good or bad for them, and that's very important. And so, because many jurisdictions have welfare laws which protects the interest, the well-being of animals, I think it follows that at least on a particular theory of rights, which is the interest theory of rights, that many animals in many jurisdictions, at least have these thin rights because of these welfare laws. So animals do have legal rights. These rights may not be may not require that they be protected from killing, from things that the animal rights movement may regard as undesirable, but they are still legal rights. And this, I think, entails that animals are subjects of the law, right? That the law is for them. The law doesn't just act upon them as it may act upon, unsentient beings like chairs or rivers or things like that, but that the law already recognizes that its purpose is to protect, at least to some extent, animals. So if we accept this, then I think we should accept the next part of the argument that if the law is for animals, then the rule of law could also be for animals. And I say could because we have different theories of what the rule of law is for. But I think my theory, which talks about arbitrary power and the implications for animals, is at least plausible. But in fact, in the paper, I defend a stronger theory that is not only plausible, is a better account because it's more inclusive.
One of the things you mentioned a few seconds ago was about jumping straight to fundamental rights for animals, the kind of thing that animal advocates might be really behind.
Hmm.
And in the paper, you do mention that you endorse the idea that non human animals have fundamental rights similar to human rights,
Hmm.
and that the common practices of using non human animals for food, entertainment, or labour almost always violate these rights. Now, I'm interested in whether that is compatible with all three, a formal, a substantive, and a procedural account? And if so, whether it more naturally sides with, say, a substantive account over the others?
Yeah, absolutely. So I think it is only compatible with a substantive account to a large extent, because the substantive account really recognizes animals as, I would say, intrinsically valuable. Yes, so that all their interests are worth protecting. Whereas the formal and the procedural accounts do not recognize that all the interests of animals matter for the purposes of the law. The formal account only recognizes that animals in general should not be left to the vagaries of people's arbitrary power to whatever to their will, right? That there should be some structure to how animals are treated. So no, it doesn't protect necessarily the right to life or to physical integrity or to freedom of animals. Now, the procedural account of the rule of law also doesn't necessarily recognize all the basic interests of animals, right? It recognizes their interests in being treated according to fair and independent procedures. But I think these theories, even though they may not be accepted by those that advocate for strong animal rights, they're still a big improvement from the status quo, right? Because as I've been saying throughout this conversation, a lot of animals are not even included within welfare legislation. So we have not even got to the formal account of the rule of law for animals. Advocates of animals such as the Non-Human Rights Project or so many other PETA are being thrown out of court because whenever they try to argue for animals, courts tell them, well, animals are not really they don't really have legal rights yet. You have to go to the legislature, and the legislature may or may not grant them rights. But on my theory, this is misguided, and I don't claim that this is an original claim at all. Others have made similar claims, but even the formal and the procedural account, while they may not satisfy the vegan activists among us, are still a big improvement from the status quo.
I did have another question about activism as well.
Hmm.
During your discussion of formal approaches to the rule of law, you talk about there being a moral duty to oppose unjust regimes.
Hmm.
And in a footnote, you approvingly mentioned the work of Candice Delmas on resistance.
Yeah.
Now, Delmas defends what we might call uncivil disobedience, which could include law breaking and even violence.
Hmm.
Now, I certainly don't want to put you on the spot, but I wondered where you stand on disobedience, including perhaps even uncivil disobedience, in response to those states that fail to recognise our duties to animals.
Yes, so this is a great question, especially when activists such as the Extinction Rebellion are engaging in forms of civil disobedience, gluing themselves to McDonald's to protest the animal industry, the animal husbandry industry, consumption industry. I am totally sympathetic to their aims. Yes, I think that even though I personally would not engage in those acts because I think my skills are better employed elsewhere, such as writing this paper, that the process of resisting injustice just justify some acts that are civilly disobedient, even though that entails often law breaking. I don't think that the law is all that it's put up to be. Sometimes the law is an ass, as the late John Gardner said famously. So, in those circumstances, of course, we should resist the law, and acts of civil disobedience form part of that strategy. Now, whether I approve more readily of the acts of extinction rebellion, which use non-violent means to resist the law. I'll be more troubled by violent acts of civil disobedience. But insofar as they are uncivil, as they are loud and disorderly, but still non-violent, I'm all in support.
Now, John, we ask every guest on Knowing Animals 5 quick questions. Are you ready for your 5 quick questions?
Yeah.
Can you recall the first piece of pro-animal scholarship you ever read?
I must have read a few pieces before this, but the piece that I remember most vividly is the one written by Raphael Fazel in Jurisprudence, and he questions the commonplace of the human rights. Commonplace, right? So, just in virtue of being human, that's the title of the article published in Jurisprudence, and it's a great article because it demystifies human rights and opens up the space for animal rights.
Can you recall the first piece of pro-animal scholarship you ever wrote?
Yeah, so I'm quite young in the animal rights movement scholarship, but the first piece of pro-animal piece I wrote was a book review of Cochrane's sentience book that was also published in Jurisprudence.
If you had to name one animal studies scholar who's had a big impact on you, who would it be?
I guess Raphael Fazel, because we write together and is the one that's been encouraging me to explore this part of my scholarship.
What's the most important thing that academics can do for animals?
I think they should use their academic skills, and we shouldn't be afraid to teach about animal rights. Of course, because we're academics, we have to look at all sides of the arguments, but in good conscience to speak about the side of the argument that we favor, right? While being open to all sides of the argument. So we should just do scholarship on animal rights.
And if you had the power to change one thing about the human-non-human animal relationship, what would it be?
Exploitation. We should just stop exploiting animals because they are not ours. They are not our property. They live with us, so we should live with them without this exploitative attitude.
And what are you working on next?
I'm currently working on a paper on a liberal defense of no platforming, which is a part of cancel culture, and also working on the liberal origins of religious freedom. So a liberal critique of religious freedom. Oh yeah, and of course the animal rights book with Raphael Fazel, which is a long-term project.
And how can people find out more about your work?
Yeah, you can follow my academia.edu page, or you can look at my Twitter feed, which I mainly dedicate to my academic work. If you Google John Adenitire, you might bump into a guy dancing salsa all the time. That is also me, but I also do academic work, and you can, of course, find me on Academia or Twitter. Yeah.
Well, thanks, John, for joining us for this podcast.
Thank you so much, Josh. It's great to be here and have the opportunity to talk about my work. Thanks a lot.
And thank you, listeners, for joining us for Knowing Animals, the podcast where we talk to animal studies scholars about their work. Don't forget to follow us on Twitter at knowing_animals or on Facebook, and you can just find us at Knowing Animals. You can also follow me on Twitter at Josh L. Milburn, or on Instagram if you want to see lots of pictures of my vegetables at A Vegan Philosopher. Also, don't forget to tell others about us and to review the podcast on iTunes. Reviews make it easier for others to find us. I'm Josh Milburn, and I do like knowing animals.
For more great iRaw podcasts, visit irawpod.com. That's IROARPOD.com.